Before we begin, a quick and important disclaimer. The information in this video is for educational and entertainment purposes only and does not constitute legal advice. This presentation is not a substitute for professional legal counsel, and watching it does not create an attorney-client relationship. Every legal situation is unique, and you should always consult with a qualified attorney for advice regarding your individual circumstances. The blue and red lights fill your rearview mirror, painting your dashboard in strobing flashes of panic. Your heart hammers against your ribs, a frantic drumbeat against the sudden silence of the car stereo you just killed. You pull over, your hands trembling slightly on the wheel. An officer approaches, a shadowy figure against the blinding headlights. Questions are asked. Your words get tangled. And then the moment that splits your life into a before and an after. The cold, metallic click of handcuffs around your wrists. Your mind is a vortex of confusion and terror. What did I do wrong? What are my rights? What happens now? In that moment, your entire future feels like it's hanging by a thread, and you have one phone call. Who do you call? You call a criminal defense lawyer. But what does that person actually do? If your only reference is television and movies, you probably picture a slick, fast-talking shark in a $1,000 suit, delivering a dramatic courtroom speech that makes a witness break down on the stand and confess everything. You imagine them pulling a surprise piece of evidence out of a briefcase at the last second, leading to a slow-motion acquittal as the music swells. Let me tell you right now, that's about 1% of the job, maybe less. That's the Hollywood fantasy. The other 99%. That's the part that happens in the shadows in quiet offices, in sterile interrogation rooms, and in the labyrinthine corridors of the courthouse. The other 99% is the real work. And it's the only thing that actually stands between an accused person and the full crushing weight of the government. In this video, we are pulling back the curtain. We're going to ignore the courtroom theatrics and show you what a criminal defense lawyer really does, from the moment that 3 a.m. phone call jolts them awake, all the way to a final verdict. And you need to understand this not because you plan on breaking the law, but because the American criminal justice system is a vast, powerful, and incredibly complex machine. And sometimes innocent people get caught in its gears. A misunderstanding, a case of mistaken identity, being in the wrong place at the wrong time, or a flat-out false accusation, it happens every single day. Over 10 million arrests are made in the United States every year. That's one every 3 seconds. Knowing how the system works and knowing the role of the one person whose entire job is to protect you from it is not criminal knowledge. It's essential civic knowledge. It's about understanding the rights that you, as an American, are guaranteed by the Constitution. So, let's get one of the biggest misconceptions out of the way first. People often ask, with a hint of suspicion, how can you defend those people? People who are guilty. It's a fair question, but it's based on a flawed premise. A defense lawyer's job is not to decide if someone is guilty. That is the exclusive job of a judge or a jury. A defense lawyer's job is to defend their client. Period. Their role is to be the champion for the accused, to hold the government to its immense burden of proof. The prosecution, the state, the government has nearly unlimited resources. They have the police departments, the crime labs, the investigators, the full power of the state. The accused has their lawyer. That's it. The defense lawyer is the one person who ensures the system, as powerful as it is, plays by its own rules. They are the guardians of the phrase, innocent until proven guilty. Without them, that phrase is just empty words. They force the state to prove its case beyond a reasonable doubt. If the state can't meet that very high standard, then under our system of laws, the person is not guilty. It's not about finding loopholes or twisting the truth. It's about upholding the highest principles of American justice for every single citizen, regardless of who they are or what they've been accused of. Think of a defense lawyer not just as a lawyer, but as a combination of 4 distinct professions. First, they are a strategist. The moment they take a case, they are playing a high-stakes chess match against a formidable opponent. Every single move, from what to say at a bail hearing, to which motions to file, to what questions to ask a witness, is a calculated decision designed to achieve the best possible outcome. They have to think 10 steps ahead, anticipating the prosecution's strategy and planning their countermoves. Second, they are a private investigator. They don't just take the police report at face value. Good lawyers and their teams will re-interview witnesses, who often change their stories or reveal details the police missed. They'll visit the scene of the alleged crime to understand the layout, the lighting, the sightlines. They'll dig for new evidence, find new witnesses, and scrutinize every single piece of the prosecution's case for weaknesses, inconsistencies, and procedural errors. Did the police have a legal right to conduct that search? Was the confession obtained legally? Is the chain of custody on that piece of evidence airtight? This investigative work is the foundation of any strong defense. Third, they are a counselor and a crisis manager. Their client is often going through the worst experience of their entire life. They're scared, they're facing the loss of their freedom, their job, their reputation, their family. The lawyer is their guide through this terrifying process. They have to explain complex legal procedures in simple terms, manage expectations, and provide a steady, calming presence in the middle of a storm. They are the one person the client can speak to with absolute, legally protected confidentiality. And finally, yes, they are an advocate and a negotiator. While the dramatic trials get all the attention, the vast majority of criminal cases in the United States, upwards of 95%, never go to trial. They are resolved through plea bargains. This is where the lawyer's skill as a negotiator is paramount. Armed with the weaknesses they found in the prosecution's case during their investigation, they will argue, reason, and bargain with the prosecutor to get charges reduced, or to secure a more lenient sentence, or in some cases, to get the case dismissed entirely before it ever sees the inside of a courtroom. This is where most battles are won. It's not glamorous, it doesn't make for good television, but it is brutally effective. So let's go back to that moment. The click of the handcuffs. You're in the back of a police car. Your world has shrunk to the cage behind the driver, and the blur of streetlights passing by the window. You arrive at the station. You're fingerprinted, photographed, and put in a small cold room. An officer comes in, maybe offers you a coffee and says, "Why don't you just tell us what happened?" If you cooperate, it'll be easier for you. This is the first and most critical test. And it's the first place your lawyer, who you haven't even met yet, begins to work for you. Because the first thing they will ever tell you, the advice that echoes from every defense attorney across the country, is this: you say nothing. You ask for your lawyer. You say those two sentences and then you remain silent. You don't explain, you don't deny, you don't try to talk your way out of it. You invoke your right to remain silent and your right to an attorney. And that is where our story truly begins. The first phone call. It's 3 a.m. A phone rings, waking the lawyer from a dead sleep. On the other end is a collect call from the county jail, or a panicked cry from a family member. "My son has been arrested. They took my husband. I'm in jail and I don't know why." The lawyer's mind instantly shifts from sleep to strategy. Their first questions are always the same. Where are you? What are they saying you did? And most importantly, have you said anything to the police? The answer to that last question can change the entire trajectory of the case. The lawyer's first job isn't to get you out. It's to stop you from making things worse. Their first act of defense is to build a wall of constitutional protection around you. And the first brick in that wall is your silence. That silence is an active defense. It's a fortress. Because the moment you start talking, you're not explaining your way out of trouble. You're handing the prosecution free ammunition. Every word you utter can and will be twisted, recontextualized, and weaponized against you in a courtroom. Let's imagine a scenario. You're driving home from a colleague's retirement party. You had 2 beers over 3 hours. You feel fine. Suddenly, you see flashing lights in your rearview mirror. Your heart hammers against your ribs. You pulled an illegal U-turn you didn't even realize was illegal. The officer approaches your window. He's polite, professional. He smells the faint odor of beer on your breath. "Sir, have you had anything to drink tonight?" he asks. This is the first test. Your brain screams to be helpful, to be honest, to de-escalate. You think, if I'm honest, he'll see I'm a good guy and let me go. So you say, "Yes, officer. I had 2 beers at a work party." Mistake number 1. You have just admitted to drinking and driving. You haven't admitted to being impaired, but you've given the state its first crucial puzzle piece. Before you said that, the officer only had a suspicion. Now he has your own admission. It's the foundation of his case. He asks you to step out of the car. He wants to conduct a field sobriety test. You're nervous. The ground is uneven, it's dark, and the flashing lights are disorienting. You try your best on the walk-and-turn test, but you lose your balance for a split second. You struggle with the one-leg stand because you have a bad knee from a high school football injury. The officer asks, "Are you having trouble with these tests?" Again, you want to be helpful. You want to explain. "I'm sorry, officer. I'm just really nervous, and my old knee injury is acting up." Mistake number 2. What did the prosecutor hear? He didn't hear bad knee. He heard you admit you were having trouble with the tests. He'll argue to a jury that your nervousness was a sign of guilt. You were nervous because you knew you were intoxicated. Your explanation just became corroborating evidence for your supposed impairment. Finally, the officer asks you to take a preliminary breath test. You know you're not drunk, so you think, what's the harm? This will prove my innocence. You blow into the device. It registers a .08, right on the legal limit. You're in shock. You don't feel drunk. You had no idea you were even close. You're placed under arrest. On the way to the station, you're trying to process everything. You're a good person. You have a job, a family. You've never been in trouble. You feel the need to justify yourself. You say to the officer in the front seat, "Look, I'm so sorry about all this. It was a huge mistake. I should have just taken an Uber." Mistake number 3. And it's the biggest one yet. You just apologized. You just confessed. In the sterile, unforgiving environment of a courtroom, the prosecutor will stand before a jury and say, "Ladies and gentlemen, the defendant himself knew he was guilty. In the back of that police car, he confessed. He said, it was a huge mistake, and he apologized for his crime. In the space of 15 minutes, by trying to be honest and helpful, you have single-handedly built the case against you. You admitted to drinking, you admitted to performing poorly on the tests, and you apologize for your conduct. Now rewind. Let's see what happens when a lawyer gets involved from the very beginning. The lights flash. The officer asks, "Sir, have you had anything to drink tonight?" Your response, coached by your lawyer, is calm and respectful. "Officer, I do not want to answer any questions." The officer asks you to step out and perform field sobriety tests. You say, "Officer, I am not willing to take any tests without my attorney present." He asks you to take a breathalyzer. You say, "I do not consent to any searches, including a search of my breath or blood, without a warrant." Now, depending on your state's implied consent laws, refusing a chemical test can have consequences, like a license suspension. But your lawyer will tell you that a suspended license is infinitely better than a criminal conviction. One is an administrative problem, the other is a life-altering event. In this scenario, you've given the prosecution nothing. No admission of drinking. No clumsy tests to be picked apart on camera. No apology to be twisted into a confession. The state now has to build its case on much weaker evidence, maybe just the officer's observation that he smelled alcohol. That is a much harder case for them to prove beyond a reasonable doubt. This is what a defense lawyer actually does first. They stop the bleeding. They build that wall of silence. And once that wall is secure, their real investigation begins. They aren't just taking your word for it. They aren't just taking the police's word for it. They become a detective for the defense. The first thing they do is file a motion for discovery. This is a formal legal demand for every single piece of evidence the prosecution has against you. And I mean everything. The official police report, of course, but also the officer's raw, handwritten notes from the scene, the dispatch call audio, the maintenance and calibration logs for the breathalyzer machine, and most importantly, the crown jewel of modern defense, the body camera and dashcam footage. A defense lawyer watches that footage like a film director analyzing dailies. They aren't just watching what you did, they're watching what the officer did. Did the officer follow proper procedure for the traffic stop? Did he have a legal reason to pull you over in the first place? If not, everything that follows could be thrown out as fruit of the poisonous tree. They watch the field sobriety test. The police report might say you failed the test, but the video might show something different. It might show the officer giving the instructions incorrectly. It might show you performing the test on a sloped, poorly lit patch of gravel, making it impossible for anyone, drunk or sober, to pass. It might show the officer's own body language suggesting he'd already made up his mind to arrest you before the test even began. The lawyer will scrutinize the calibration logs for the breathalyzer. Was the machine serviced on time? Was it operating correctly? These are sensitive scientific instruments, not magic boxes. A failure to properly maintain the device can completely invalidate its results. They will read every word of the police report and compare it to the video. Does the officer's written narrative match the visual reality? You'd be shocked how often it doesn't. An officer might write, "The suspect was belligerent and uncooperative," while the video shows a person who is calm, quiet, and scared. This discrepancy isn't just a small detail. It's a direct attack on the officer's credibility. which is often the entire foundation of the state's case. This initial phase is not about finding a dramatic, aha, gotcha moment like on TV. It's about a patient, methodical search for cracks, for inconsistencies, for procedural errors, for any detail that casts doubt on the official story. The lawyer is searching for the seeds of reasonable doubt. And once they have all of this information, the good, the bad, and the ugly, they can finally begin to map out a strategy. They can see the strengths and weaknesses of the prosecutor's case, and they can see the potential paths forward. This deep dive into the evidence is what separates a real defense from a simple surrender. The lawyer's job isn't to create a story. It's to find the truth hidden within the prosecution's own evidence, and to expose the parts they hope you'll never see. With this arsenal of information, the lawyer is now ready to move from defense to offense. They are ready to start challenging the state's case, not in front of a jury, but in the closed-door arenas where most legal battles are actually won or lost. These arenas are not back alleys or smoke-filled rooms. They are courtrooms, but they are courtrooms empty of a jury. They are judges' chambers. They are the battlegrounds of paper and precedent, where a lawyer wields their most powerful weapon, the pretrial motion. This is the legal equivalent of a targeted missile strike, designed to dismantle the prosecution's war machine before it ever reaches the main battlefield of a trial. It's an entire phase of the case called motions practice, and it's where the best lawyers earn their reputations. A motion is simply a formal request asking a judge to make a ruling or take a specific action, but that simple definition hides its incredible power. It's a lawyer's chance to say to the court, "Your Honor, the government didn't play by the rules, and because of that, this piece of evidence or even this entire case should be thrown out." Let's start with the most famous and perhaps most potent of these, the motion to suppress evidence. This motion is based on the Fourth Amendment of the United States Constitution, the one that protects you from unreasonable searches and seizures. It's the legal mechanism to enforce that right. Imagine your client, let's call him Mark, was pulled over for a broken taillight. A simple traffic ticket, but 10 minutes into the stop, the officer is still asking questions. 15 minutes in, he's asking to search the car. Mark, nervous and intimidated, says no. 20 minutes in, the officer says, "Stay right there," and calls for a K9 unit. The dog arrives, sniffs around the car, and signals that it smells drugs. The officers now claim they have probable cause. They search the car and find a bag of marijuana under the seat. Mark is arrested and charged with drug possession. On the surface, the case looks open and shut. The police found the drugs in his car. He's factually guilty. The prosecutor offers him a plea deal. Plead guilty and get probation. Seems like the only way out. But a great defense lawyer knows the facts are only half the story. The other half is the procedure. The lawyer files a motion to suppress. Now the real work begins. The lawyer subpoenas everything. The officer's body camera footage, the dashcam video from the patrol car, the dispatch logs, and the officer's training records. They comb through hours of footage, not looking for what happened but for when it happened. They sync the dispatch logs to the video timeline, creating a minute-by-minute anatomy of the traffic stop. And then they find it. At the 6-minute mark, the video shows the officer handing Mark the ticket for the broken taillight. The purpose of the stop, the reason the government was allowed to interfere with Mark's freedom of movement, was officially over at that moment. But the officer didn't let him leave. The lawyer checks the dispatch logs. The call for the K9 unit wasn't made until the 12-minute mark, a full 6 minutes after the ticket was written. This is the kill shot. The lawyer's motion argues that the officer illegally prolonged the traffic stop without reasonable suspicion. They cite a landmark Supreme Court case, Rodriguez v. United States, which states that police cannot extend an already completed traffic stop, even for a few minutes, just to conduct a drug sniff. The officer's authority to detain Mark evaporated the second he handed him that ticket. Every second he was held after that was an unconstitutional seizure of his person. The day of the motion hearing arrives. There's no jury, just the lawyer, the prosecutor, the judge, and the police officer on the witness stand. The prosecutor has the officer walk through the stop, making it sound routine. Then it's the defense lawyer's turn to cross-examine. They don't yell. They don't point fingers. They calmly walk the officer through his own video. Officer, at timestamp 14 hours 32 minutes and 6 seconds. Is that you writing the citation? Yes. And at 14 hours 38 minutes and 15 seconds, is that you handing the completed citation to my client? Yes. So at that point, officer, the business of the traffic stop was concluded, correct? The officer hesitates. "And yet, you instructed my client to remain in his vehicle, didn't you?" "Yes." "And you did not call for the K9 unit for another 6 minutes, is that right?" The lawyer has laid the trap, and the officer has walked right into it. The argument to the judge is simple and devastating. The evidence was found, yes, but it was found as a direct result of a constitutional violation. This is the fruit of the poisonous tree doctrine. The illegal detention was the poisonous tree, and the drug evidence is its tainted fruit. The court cannot allow the government to benefit from its own illegal conduct. The judge listens, reviews the law, and makes a ruling. The motion to suppress is granted. With that one sentence, the entire case evaporates. The drugs, the only piece of evidence the prosecution had, are now inadmissible. They cannot be mentioned or presented at trial. The prosecutor has no choice but to file a motion to dismiss the charges. Mark, who was factually guilty, walks out of the courthouse a free man. Not because of a loophole, but because his lawyer forced the system to obey its own rules, rules that protect every single citizen from government overreach. This is what a defense lawyer actually does. It's not about denying reality. It's about holding power accountable. But it doesn't stop there. What if the evidence was obtained legally, but the case itself is fundamentally flawed? That's where a motion to dismiss comes in. Let's say a client is accused of robbery, based on a single eyewitness who picked him out of a photo lineup. The lawyer investigates the lineup procedure. They discover that their client's photo was the only one with a different colored background. Or maybe he was the only one not smiling. These seemingly small details can be incredibly suggestive, subconsciously steering the witness toward a specific choice. The lawyer files a motion to dismiss, arguing that the identification procedure was so impermissibly suggestive that it violated the client's right to due process under the 14th Amendment. It created a substantial likelihood of misidentification. At the hearing, the lawyer might even bring in an expert witness on eyewitness memory to explain to the judge how easily a witness can be influenced. If the judge agrees that the identification is unreliable and should be thrown out, and there's no other significant evidence linking the client to the crime, the entire case can be dismissed right then and there. Other motions can challenge the jurisdiction of the court, argue that a statute is unconstitutional, or demand that the prosecution turn over evidence they've been hiding, evidence that could prove the client's innocence. Each motion is a strategic attack, designed to probe for weaknesses and create leverage. Because every piece of evidence suppressed, every charge dismissed, every procedural victory fundamentally changes the balance of power. It weakens the prosecutor's hand and strengthens the client's position. This relentless behind-the-scenes assault on the government's case is the unseen engine of the criminal justice system. It ensures that a conviction isn't just about what a person did, but about whether the government has proven its case legally, ethically, and constitutionally. And it's after these initial battles are fought, after the smoke clears and both sides see what evidence is left standing, that the next and most common phase of the process begins. The high-stakes negotiation for a person's future, a process where over 90% of all criminal cases in America are ultimately resolved. This is the real courtroom, the one that doesn't make it onto television. It's not a room of polished wood and leather-bound books. It's a series of hushed phone calls, tense meetings in sterile government offices, and hurried conversations in courthouse hallways. This is the world of the plea bargain. And for a criminal defense lawyer, this is where the vast majority of their battles are fought and won or lost. The very idea of a plea bargain can feel wrong to a lot of people. It sounds like horse trading with justice. If someone is guilty, why are we giving them a deal? And if they're innocent, why would they ever plead guilty to something they didn't do? These are the exact questions that haunt the process, but to understand what a defense lawyer does, you have to understand why this system exists. First, look at it from the prosecutor's side. District attorneys' offices are almost always overwhelmed. They have hundreds, sometimes thousands of active cases, and a limited number of prosecutors and courtrooms to handle them. They simply cannot take every single case to trial. It would be like trying to empty the ocean with a bucket. The entire justice system would collapse under the weight. So for them, a plea deal is a guaranteed conviction. It clears a case off their desk, saves taxpayer money, spares witnesses and victims the trauma of testifying, and avoids the single biggest fear of any prosecutor: losing a high-profile case at trial and having a defendant they believe is guilty walk free. A guaranteed 5-year sentence today is often seen as a much better outcome for the state than the possibility of a 20-year sentence after a risky, week-long trial a year from now. Now look at it from the defense side. The client is facing what's known as the trial penalty. This is a terrifying, unspoken reality of the American justice system. Let's say a client is charged with a robbery that carries a maximum sentence of 15 years. The prosecutor offers a deal. Plead guilty, and will recommend a sentence of 3 years. If the client rejects that deal and goes to trial, they are rolling the dice. If a jury of 12 strangers finds them guilty, the judge isn't going to give them the 3 years they were offered before. Why would they? The defendant didn't accept responsibility, they didn't save the state the cost of a trial, and they forced victims to relive their trauma on the stand. So the judge, now looking at the same facts, might sentence them to 10, 12, or even the full 15 years. The penalty for exercising your constitutional right to a trial is severe. This is the brutal calculation the defense lawyer must now navigate. Their job transforms from investigator and legal scholar into a master negotiator, a strategist, and a brutally honest counselor. The first thing the lawyer does is marshal their leverage. All that work from the investigation and the motion practice wasn't just for show. Every weakness they found in the prosecutor's case is now a bargaining chip. The lawyer doesn't walk into the DA's office and say, "Hey, can you be nice to my client?" They walk in and say, "Let's talk about your case. The evidence you found in my client's car? It's gone. The judge suppressed it because of an illegal search. The confession you got? My client wasn't read his Miranda rights, so that's out too. Your star witness has 2 prior convictions for perjury, which I will be sure to bring up to the jury. And the other witness's description of the suspect is 6 inches off my client's height and describes a different hair color. So you can either take this weak case to trial and risk a full acquittal, or we can resolve this right now with a plea to a much lesser charge." This is the art of negotiation. It's about systematically dismantling the prosecutor's confidence in their own case, piece by piece, until the deal they're willing to offer gets better and better. But it's not just about the facts and the evidence. A great defense lawyer knows that they are not negotiating a case file. They are negotiating for a human being. A prosecutor might look at a file and see case 2024-1875, defendant, John Smith, charge, possession with intent to distribute. The defense lawyer's job is to force them to see more than that. The lawyer tells John's story. This isn't just a drug dealer. This is a guy who got hooked on painkillers after a construction accident. He lost his job. His wife left him. He started selling to support his own habit because he was desperate. But since his arrest, he's been in a treatment program for 60 days. He's clean. He has his father, a pastor, willing to let him live at home. He has a job offer waiting for him at his uncle's garage. If you send this man to prison for 5 years, you destroy any chance he has of putting his life back together. But if we can agree to a sentence of intensive probation with mandatory drug testing and treatment, you can actually solve the problem that led him here. This is the human element. It's about transforming a statistic into a story, a defendant into a person. It's a plea for empathy, backed by the cold, hard leverage of a potentially weak case. While all this is happening with the prosecutor, the lawyer is having some of the most difficult conversations of their career with their own client. They have to become a dispassionate risk analyst. They explain the trial penalty in stark, unforgiving terms. They'll say, "Here is the offer on the table, 2 years of probation. If you take it, you go home today, but you'll have a misdemeanor on your record. If we go to trial, I believe we have a good, maybe 60% chance of winning. But if we lose, if just one of those 12 jurors is having a bad day or just doesn't like the look of you, you are facing a mandatory minimum of 5 years in prison. Not maybe, not possibly, 5 years guaranteed. The decision is yours and yours alone. I will fight for you tooth and nail no matter what you choose. But you need to understand the cliff you're standing on." And this brings us to the most gut-wrenching part of the entire system. Innocent people plead guilty. They do it every single day in America. Imagine you're that person. You didn't do it, but your lawyer tells you the evidence against you is strong, even if it's misleading. A witness misidentified you. The police made a mistake. But the prosecutor has a compelling story to tell a jury. Your choice is to plead guilty to a crime you did not commit and get probation, allowing you to go home to your family and keep your job. Or you can maintain your innocence, roll the dice on a trial and risk losing, which would mean a decade in prison, losing your children, your home, everything you've ever known. What do? It's an impossible choice. It's a choice between a small certain injustice and a potentially catastrophic life-destroying one. and the defense lawyer has to be the one to guide the client through that impossible, soul-crushing decision. This delicate dance of negotiation, of leveraging legal weaknesses while simultaneously humanizing the client, can go on for months. Offers and counteroffers fly back and forth. The lawyer is constantly re-evaluating the strength of the case as new information comes to light, and constantly counseling a client who is living in a state of pure terror. They are a warrior in one room and a counselor in the next, fighting the state with one hand while holding their clients with the other. But sometimes the dance stops. Sometimes the prosecutor's offer is simply too high, a number the client cannot accept. Or sometimes the client, standing on the principle of their own innocence, looks their lawyer in the eye and says, "I don't care what the risk is. I didn't do this, and I will not say that I did." When that happens, all negotiations end. The phone calls stop. The handshakes are withdrawn, and the defense lawyer must then turn their full attention to preparing for the single most dramatic and consequential event in the entire American legal system: the trial. This is not a surrender. It's a declaration of war. And the law office transforms from a place of negotiation into a tactical command center, a war room where the battle for a person's future will be planned, mapped, and rehearsed down to the smallest detail. The public sees the courtroom clashes, the dramatic objections, the final verdict. But they almost never see this: the months of grueling, relentless, and often mind-numbing work that truly wins or loses a case. This is where the real fight happens. It begins with an avalanche of paper and data called discovery. The prosecution is constitutionally required to turn over all the evidence it has against the defendant. This isn't a neat little folder with a summary. It's a digital data dump. It's hundreds, sometimes thousands of pages of police reports, dense with jargon and acronyms. It's hours upon hours of body camera and dashcam footage. It's blurry surveillance video from 3 different angles. It's crime lab reports filled with scientific terminology, witness statements, victim interviews, phone records, text message logs, social media data. It is a mountain of information, and the prosecutor's version of the story is sitting right on top. A defense lawyer's first job is to become an expert on that mountain. They must read every single word. They must watch every single second of video. Why? Because the case isn't won by looking at what the police and prosecutor highlight. It's won by finding what they missed, or what they ignored. The lawyer is looking for the single sentence in a 90-page report that contradicts the arresting officer's main claim. They're watching 12 hours of body cam footage to find the 3-second clip where a witness says something that completely undermines their official statement. They're scrutinizing a timestamp on a security camera that proves their client couldn't have been where the prosecution says they were. This is not glamorous work. It's done late at night, fueled by coffee, with a highlighter in one hand and a legal pad in the other. It's a search for a single golden needle in a vast, sprawling haystack of data. While they're absorbing this information, they begin the second critical phase: deconstruction. The lawyer's job is to take the prosecution's case, this seemingly perfect, solid structure, and find the cracks. They become a demolition expert. They start asking questions. Did the police have probable cause to pull the car over in the first place? Was the search warrant they used to enter the house properly filled out and signed by a judge? Was it based on reliable information, or a flimsy tip from a questionable informant? They investigate something called the chain of custody. That bag of evidence, the alleged drugs or the weapon. Can the prosecution prove step by step exactly who had it, where it was, and what was done to it from the moment it was collected at the scene to the moment it's presented in court? A single broken link in that chain, a single hour unaccounted for, can make that evidence inadmissible. This hunt for errors leads to one of the defense lawyer's most powerful and least understood weapons: the pretrial motion. A motion is simply a formal request for a judge to do something. And the most devastating of these is the motion to suppress. This is where the lawyer argues that a key piece of the prosecution's evidence was obtained illegally, in violation of the client's constitutional rights. For example, if the police searched a car without a warrant and without a valid legal exception, the lawyer will file a motion to suppress whatever they found. There will be a mini-hearing, long before a jury is ever selected. The police officers will testify. The lawyers will argue. And if the judge agrees that the search was illegal, that evidence is gone. It's poisoned. The jury will never hear about it, never see it. And if that suppressed evidence was the entire basis for the case, the drugs in the trunk, the gun under the seat, the case can be won right then and there without ever going to trial. The charges are dismissed. The client walks free. These pretrial battles are the invisible wars that often decide the outcome before the main event even begins. But a good defense isn't just about poking holes. You can't win a trial just by saying they didn't prove it. A jury needs a story. They need an alternative narrative that makes sense. So, the lawyer must now become a storyteller, a scriptwriter. They develop a theory of the case. This is the central theme, the story that will be told to the jury. Is it a case of mistaken identity? Was the client in the wrong place at the wrong time? Was it an act of self-defense? Was the confession the police got coerced after 10 hours in an interrogation room without a lawyer? Or is the theory simpler? The police investigation was sloppy, they jumped to conclusions, and they arrested the wrong person while the real culprit is still out there. Every piece of evidence, every question asked, every witness called will serve this one single narrative. This story becomes the blueprint for the entire trial. And to tell that story, you need characters. You need witnesses. Preparing witnesses for trial is one of the most psychologically intense parts of the job. It is absolutely not about telling them what to say. That's illegal and unethical. It's about preparing them for the brutal, hostile environment of cross-examination. The lawyer will often play the role of the prosecutor in practice sessions, sometimes called murder boards. They will be relentless. They'll ask invasive, personal questions. They'll twist the witness's words. They'll try to make them angry, to fluster them, to make them contradict themselves. Feels cruel, but it's necessary. It's a stress test. The goal is to train the witness to stay calm, to listen to the exact question being asked, and to answer only that question truthfully and concisely, without getting dragged into the prosecutor's traps. When the client is the one taking the stand, this process is even more critical. Their life is on the line, and their performance on the witness stand, their credibility in the eyes of the jury, can be the single factor that decides their fate. Finally, with the evidence analyzed, the motions filed, and the story built, the lawyer must turn their attention to the audience, the jury. Jury selection, or voir dire, is a fascinating mix of law, psychology, and pure gut instinct. The lawyers for both sides get to ask questions of potential jurors. And they aren't just looking for obvious bias. They're trying to read people. They're looking at body language, at word choices, at life experiences. A prosecutor might not want someone on the jury who has had a negative experience with law enforcement. A defense lawyer might be wary of someone who is very trusting of authority figures. They are looking for subtle clues. Does this person seem like a leader or a follower? Are they open-minded or rigid in their thinking? Can they understand complex ideas? Each side gets a certain number of peremptory challenges, which allow them to strike a juror for almost any reason at all, no explanation needed. It is a high-stakes strategic game of human chess, trying to assemble 12 people who are, at the very least, capable of giving your client a fair shot. In the final days before the trial begins, the lawyer's office is a vortex of controlled chaos. They are organizing hundreds, if not thousands, of documents into massive trial binders, with every exhibit, every report, every potential piece of evidence tabbed and ready. They are rehearsing their opening statement over and over, refining every word, every phrase, trying to craft a powerful first impression that will stick with the jury for the entire trial. They are anticipating the prosecutor's moves, planning their countermoves, and preparing for the unexpected. They are living and breathing the case. It consumes their thoughts when they wake up and haunts their sleep at night. Because all of this, the thousands of pages read, the hundreds of hours of video watched, the legal arguments crafted, the witnesses prepared, the jury strategy plotted, all of it has been leading to a single moment. It's the moment they push their chair back, stand up, smooth out their suit, and walk toward that courtroom door. Everything that happens next happens in public. And it all begins with 7 simple words. All rise. The court is now in session. Those 7 words hit like a physical force. The air in the room, already thick with tension, becomes electric. Every sound is amplified. The squeak of a leather shoe, a nervous cough from the gallery, the heavy thud of the judge's gavel. This is the arena. And for the next few days or weeks or even months, it is the entire world for your lawyer and the person they represent. Everything that happened before, the investigation, the negotiations, the sleepless nights, was practice. This is the game. And the first play, arguably the most important one of all, is about to begin. It's called voir dire, a French term that means to speak the truth. We call it jury selection, but that's a misleading name. A lawyer doesn't select a jury. They don't get to look at a pool of 100 citizens and handpick the 12 they like best. It's the opposite. Their job is to deselect. Their mission is to identify and remove the people who are most likely to convict their client before a single piece of evidence has been presented. This is where a defense lawyer stops being just a legal scholar and becomes a psychologist, a mind reader, and a master of human intuition. The prosecutor and the defense attorney are each given a list of potential jurors. One by one, they are called up to the jury box to be questioned, and the dance begins. The prosecutor will ask questions designed to find people who are tough on crime, who trust law enforcement, who believe in strict order. Do you believe a police officer's testimony is inherently more credible than a civilian's? Have you ever had a negative experience with law enforcement? They're looking for allies. Then it's the defense lawyer's turn. Their questions are designed to uncover the hidden biases we all carry. They aren't just listening to the answers. They're watching how they're answered. Does the juror cross their arms when the defendant is mentioned? Do they make eye contact? Does their voice tighten when they talk about the type of crime at issue? The questions are surgical. The judge will instruct you that the defendant is presumed innocent. Intellectually, we all understand that. But in your heart, seeing him sitting here accused by the state, do you feel like he probably did something wrong? It's a brutal, direct question. A hesitant no can be more revealing than a confident yes. They'll probe for life experiences. Has a close friend or family member ever been the victim of a violent crime? A juror who has will likely bring that trauma into the deliberation room. Do you have any training in science or accounting? If it's a complex financial case, the lawyer needs to know who can follow the details and who might get lost and just vote with their gut. For every potential juror, the lawyer has to make a snap judgment. Is this person a leader or a follower? Are they analytical or emotional? Are they open-minded, or are their opinions set in stone? If a juror openly admits a bias, like saying, "I think all drug dealers should be locked up forever in a drug case," the lawyer can ask the judge to strike them for cause. But the real art is in using what are called peremptory strikes. Each side gets a limited number of these, and they can use them to remove a juror for any reason at all, as long as it's not based on race or gender. This is the high-stakes poker game within the trial. The defense lawyer might have a gut feeling about a juror. They can't explain it, they can't prove it, but something in their instinct screams, "This person is a danger to my client." They have to decide, is this feeling strong enough to burn one of their precious few peremptory strikes? Or do they save it, hoping a more obviously biased juror comes along later? It's a decision that can win or lose the entire case before it even starts. Slowly, painstakingly, a jury of 12 citizens, plus a few alternates, is formed. These 12 people, strangers pulled from their everyday lives, now hold a person's future in their hands. The room falls silent again as they are sworn in, and now the storytelling begins. The trial starts with opening statements. This is not evidence. It's a preview. It's a promise. The prosecutor always goes first because they have the burden of proof. They stand before the jury, confident and clear, and they lay out their version of reality. "Ladies and gentlemen of the jury," they'll begin, "this is a simple case. On the night of May 14th, the defendant, John Smith, broke into the home of the victim. The evidence will show you that his fingerprints were on the door. A witness will testify that they saw his car speeding away from the scene. And you will hear a confession, in the defendant's own words. At the end of this trial, we will ask you to find him guilty, because that is what the evidence demands." It's a powerful, straightforward narrative, a roadmap to conviction. The jury listens, rapt. For many of them, this story now becomes the default reality. Then the defense lawyer stands up. Their job is infinitely harder. They don't have to prove their client is innocent. They just have to create a crack in the prosecutor's story. A single nagging question. A sliver of reasonable doubt. Their opening statement is the first tool they have to do this. They walk towards the jury, making eye contact with each person they fought to get on that panel. Their tone is different. It's not about certainty. It's about questions. "What you just heard," they might say, "is a story. It's a neat, tidy story that the prosecution has spent months putting together." But stories can be deceiving. Over the next few days, we're going to look at the things that story leaves out. We're going to talk about the fact that the so-called eyewitness only saw a car from 100 yards away at night. We're going to ask why the police ignored another suspect who had a clear motive. We're going to listen closely to that confession and hear the fear and confusion in my client's voice after being interrogated for 12 straight hours. The defense lawyer isn't presenting an alternate reality. They are introducing chaos into the prosecutor's neat little world. They are planting seeds of doubt. They're not saying, my client didn't do it. They're saying, the state cannot prove beyond a reasonable doubt that he did. They are changing the jury's job description. They're not here to solve a mystery. They're here to act as a check on the government's power, to hold the prosecution to its impossibly high burden of proof. They are making a promise to the jury. Pay attention. Listen critically. Don't just accept the story you're told. And with that promise hanging in the air, the defense lawyer sits down. The courtroom is silent. The two competing narratives have been drawn. The battle lines are clear. The prosecutor, armed with the full resources of the state, is about to begin building their case, brick by evidentiary brick. They will call their first witness to the stand, and the defense lawyer, who has been a negotiator, an investigator, and a storyteller, must now transform again. They must become a deconstructionist, a saboteur. Their entire job is to take the prosecutor's carefully constructed wall of evidence and find the one loose brick that will make the whole thing crumble. This isn't done with a single dramatic swing of a sledgehammer. It's done with 1,000 tiny taps from a surgical chisel. It's a process of introducing friction, of seeding doubt, of making the jury lean back in their chairs and think, wait a minute, is it really that simple? Because the prosecutor's job is to present a clean, straight line from your client to the crime. The defense lawyer's job is to show the jury all the messy, complicated, human squiggles that the prosecution conveniently erased. The entire defense rests on two words: reasonable doubt. We hear this phrase all the time in movies, but what does it actually mean? It doesn't mean any doubt. It doesn't mean a fantastical, what if aliens did it kind of doubt. The standard is much more profound. It's a doubt that would cause a reasonable person to hesitate before acting in a matter of the highest importance in their own life. Think about it this way. Imagine you're about to buy a house. You love it. The pictures are perfect. The seller tells you it's a dream home. That's the prosecution's case. But then your inspector, the defense attorney, comes in. He doesn't say the house is a total teardown. He just points out a small crack in the foundation, a faint water stain on the ceiling in the attic, a weird flicker in the lights that only happens sometimes. Are any of those things definitive proof that the house is a disaster? No. But would they make you hesitate before signing away your life savings? Would they give you pause? That hesitation, that is reasonable doubt. The defense attorney isn't selling the jury a new house. They're just trying to convince them not to buy the one the prosecutor is selling. The primary tool for this is the art of cross-examination. This is where the defense lawyer gets to question the prosecution's witnesses. And on TV, this is always the moment where the witness breaks down on the stand crying, "I did it. I lied." In reality, that happens almost never. The true purpose of cross-examination is far more subtle and, frankly, more brutal. It's not about finding the truth. It's about testing the truthfulness of what has been said. The lawyer's goal is to control the witness. They use leading questions, which are statements disguised as questions, designed to elicit a simple yes or no. It's not, "What did you see that night?" It's, "It was dark that night, wasn't it?" "Yes." "And you were over 100 feet away, correct?" "Yes." "And you had only seen the suspect once before for a few seconds?" "Yes." "And you weren't wearing your prescription glasses at the time, were you?" You see what's happening? The lawyer isn't calling the witness a liar. They are simply taking the witness's confident, powerful story and breaking it down into a series of small, less confident facts. They are reframing the narrative. The witness who confidently pointed at the defendant is now just a person with bad eyesight, who was far away in the dark. The lawyer is creating doubt about the witness's ability to perceive, to remember, to be certain. They will mine every prior statement the witness has ever made to the police in a deposition, looking for the tiniest inconsistency. Maybe on the night of the incident, they told the police the getaway car was dark blue. But today on the stand they say it was black. Is this a huge lie? No. But the lawyer will pounce. So your memory isn't perfect, is it? You were mistaken then, or you're mistaken now. Which is it? The point isn't that the color of the car matters. The point is to show the jury that this witness's memory is fallible. It's a small crack in the foundation, and the lawyer will tap on that crack again and again until it starts to spread. Then there's the fortress of forensic evidence. Thanks to television, we have the CSI effect. Juries see DNA, fingerprints, and ballistics as infallible scientific truth. The defense lawyer's job is to pull back the curtain and show them the wizard is just a human, and humans make mistakes. They start with something called the chain of custody. Evidence is like a package being mailed. Every single person who handles it, from the moment it's collected at the crime scene to the moment it's presented in court, has to be documented. If there's a single gap in that chain, a moment where the evidence was left unattended, or handled by an unauthorized person, the defense lawyer will argue that it's been contaminated. That DNA sample the prosecution is so proud of? How do we know it wasn't contaminated in the lab? How do we know the officer bagging it didn't accidentally sneeze? The lawyer introduces the possibility of error. Another crack. And when the prosecution brings in their star expert witness, a scientist in a lab coat who presents their findings with absolute certainty, the defense lawyer's cross-examination is crucial. They won't try to outscience the scientist. Instead, they'll attack the certainty. They'll ask questions like, "Doctor, isn't it true that the methodology you used has a known error rate? Can you say with 100% certainty that no other person on the planet could share these specific markers? Isn't it true that your analysis was based on a partial fingerprint, not a full one?" The goal is to demystify the science, to turn it from a magic bullet into what it actually is, a tool operated by humans with known limitations. They want the jury to see that a match isn't a declaration of guilt from God. It's an opinion offered by a paid expert. Throughout this entire process, you'll hear the lawyer constantly shouting objection. It can seem rude and disruptive, but it's one of the most important parts of their job. The courtroom is a game with very strict rules about what can and can't be said. The lawyer is the enforcer of those rules for their side. Objection, hearsay. This means the witness is trying to testify about something someone else told them. The law says this isn't allowed because the defense can't cross-examine the person who actually said it. They can't test their credibility. Objection, leading. This is when the prosecutor is feeding their own witness the answers. You saw the defendant looking angry, didn't you? That's putting words in the witness's mouth. Objection, speculation. This is when a witness is guessing. I think he was probably trying to hide something. They can't testify about what they think was in someone else's head, only what they actually saw or heard. Each time an objection is sustained by the judge, a piece of the prosecution's evidence, a part of their story, is blocked from ever reaching the jury's ears. The lawyer is actively filtering the information the jury receives, ensuring they only hear the evidence that is legally permissible. Each sustained objection is another brick pulled from the prosecutor's wall. Perhaps the most terrifying high-stakes decision in the entire trial is whether or not to put the defendant on the stand. The Fifth Amendment says they don't have to. Their silence cannot be used against them. But every lawyer knows that juries are human. They're curious. And when the defendant just sits there silently for the whole trial, the jury can't help but wonder, if he's innocent, why won't he just tell us? If the defendant testifies, it's a monumental gamble. It gives them the chance to tell their side of the story, to connect with the jury on a human level, to look them in the eye and say, "I didn't do this." A charismatic, well-spoken defendant can win the entire case with their testimony. But the risks are catastrophic. Once they take the stand, they are fair game for the prosecutor's own brutal cross-examination. The prosecutor can bring up most of their prior criminal convictions to attack their credibility. They will twist their words, set verbal traps, and try to provoke them into getting angry or defensive on the stand. A single slip-up, a single lie, even a small white lie, can be exposed and used to paint them as a dishonest person, destroying their credibility and their entire case. This decision is a gut-wrenching moment of truth for the lawyer and the client. They must weigh the potential for human connection against the risk of total annihilation. It's a tightrope walk over a canyon with no safety net. And the defense lawyer is the one who has to advise whether or not to take that first terrifying step. And so the lawyer prepares for a war that might happen on two fronts. The first is the war of evidence, of facts, of motions and objections. But the second, and often more dangerous war, is the war of perception, and it's fought on the witness stand. The decision of whether a defendant should testify is, without exaggeration, one of the most consequential choices in their entire life. It can be the difference between walking free and dying in a cage. The human impulse is almost always to speak, to stand up and say, "This is not who I am. You have misunderstood. Let me explain." The client believes, deep in their soul, that if the jury could just hear their side of the story, from their own mouth, that they would see the truth. They believe in the power of their own sincerity, and the defense lawyer has to be the one to tell them that their sincerity might be a weapon used to destroy them, because a prosecutor doesn't see a human being on the stand trying to explain themselves. They see a target of opportunity. A prosecutor is a professional questioner, trained in the art of psychological jujitsu. Their job is to take the defendant's own energy, their own words, their own emotions, and use it to throw them to the mat. The cross-examination of a defendant isn't a conversation. It's a dissection. And the prosecutor has the sharpest scalpels. They start with small, seemingly innocent questions. Questions about timing, about locations, about minor details from months or even years ago. The defendant, trying to be helpful, trying to be precise, gives an answer. Then another. And another. The prosecutor is not looking for information. They are collecting ammunition. They are building a web of tiny statements. Then they'll pull out a police report, a text message, a phone record. Sir, you just testified under oath that you left the house at 9 p.m. But your cell phone records, which we have right here, show you made a call that pinged a tower 2 miles away at 8:52 p.m. Were you mistaken then? Or are you mistaken now? It's a tiny discrepancy. Meaningless. But to the jury, a seed of doubt has been planted. If he's wrong about that, what else is he wrong about? If he'd lie about something so small, would he lie about something big? Then come the character attacks disguised as questions. If the defendant has any kind of prior conviction, and they choose to testify, the door can swing wide open for the prosecutor to bring it up. Mr. Smith, this isn't the first time you've been in a courtroom, is it? Suddenly, the case isn't about whether he committed this specific crime. It's about whether he's a bad guy, a criminal. The prosecutor forces them to relive and admit to their worst mistakes in front of a dozen strangers who will decide their future. The defendant gets defensive. They get angry. And that's exactly what the prosecutor wants. They want the jury to see an angry, combative person, not a scared man fighting for his life, but a guilty man lashing out because he's been caught. The lawyer's job, if the client insists on testifying, is to transform them into a soldier ready for battle. This isn't about teaching them what to say. It's about teaching them how to survive. The preparation is brutal. The lawyer becomes the prosecutor. They conduct mock cross-examinations that are far more vicious, more personal, and more relentless than anything the real prosecutor will likely do. They will insult the client. They will twist their words. They will accuse them of lying, of being a monster. They will make them cry. They will make them angry. They will push them to their absolute breaking point. The goal is to condition them, to build a callus over their raw emotional nerves so that when the real attack comes, they can withstand it. They learn to pause, to breathe, to answer only the question that was asked, to say, I don't recall instead of guessing, to be a rock in a hurricane of accusation. Most people can't do it. The pressure is too immense. The stakes are too high. This is why the Fifth Amendment is so sacred. The right to remain silent. The law is crystal clear. The jury is explicitly forbidden from holding a defendant's silence against them. They are instructed, in no uncertain terms, that it cannot be a factor in their deliberations. But lawyers know the difference between what the law says and what people do. In the quiet of the jury room, does a juror not think, well, if he was innocent, why wouldn't he just get up there and say so? It's a natural human thought, and it's a poison that can taint the entire process. The lawyer's job is to trust that the jury will follow the law, but to fear that they will follow their human nature. This all assumes the case even gets that far. The truth is, the vast majority of criminal cases in the United States, over 95%, never see a jury. They don't end with a dramatic trial and a verdict. They end with a quiet, sterile, and often soul-crushing piece of paperwork, a plea agreement. This is the shadow system of justice where most of the work is actually done. A plea bargain is a negotiation. The prosecutor holds all the cards. They have the power of the state, a budget, and a list of charges that can often be stacked higher and higher. On the other side is the defendant, with their life hanging in the balance. The prosecutor makes an offer. Look, they'll say, you're charged with a first-degree felony. If you go to trial and lose, the judge could give you 30 years. 30. But if you plead guilty right now to a lesser charge, we'll recommend a sentence of 7 years. Suddenly, the defense lawyer's role shifts from warrior to actuary. They become a risk analyst. Their job is to perform what can only be called the math of misery. They have to sit down with their client and have the most brutally honest conversation of their life. Here is the evidence against you. This is what's strong for them, this is what's weak. Here are the constitutional issues we can fight. Here is my assessment of the judge and what I think the jury might do. I believe we have a 40% chance of winning. That means there's a 60% chance you lose. If you win, you go home. If you lose, you might not see the outside world again until you're an old man. They are offering you a guarantee. Terrible guarantee. You will lose 7 years of your life. But it's a guarantee. The choice is yours. Imagine that choice. It's not a choice between right and wrong, or guilt and innocence. It's a choice between a guaranteed, definite bad outcome and the risk of a catastrophic one. And this is where the darkest, most terrifying secret of the American justice system lives. It is a system that creates such overwhelming pressure to plead guilty that it forces innocent people to confess to crimes they did not commit. Think about it. You're innocent, but the evidence is messy. A witness misidentified you. The police made a mistake, but the prosecutor has a strong case on paper. You're facing 50 years if you lose at trial. Your lawyer, who believes you, tells you that you have a 50-50 shot. Could you roll those dice? With your entire life? Or would you take the offer of 3 years? You'd go to prison for a crime you didn't do. You'd be a convicted felon for the rest of your life. But you'd be out in 3 years. You'd get your life back. What would you do? This is not a hypothetical. It happens every single day in courtrooms across the country. And the defense lawyer is the one who has to broker that deal. They have to advise their innocent client on the grim calculus of their own life. And if the client chooses to take the plea, the lawyer has to stand beside them in front of a judge. They have to watch as their client, the person they know is innocent, raises their right hand and lies to the court. Guilty, Your Honor. It is a moment of profound, institutionalized injustice. The lawyer becomes a party to a lie to save their client from a potentially greater injustice. It is a moral compromise of the highest order. And the lawyer has to walk out of that courtroom carrying the weight of that lie, knowing they just helped send an innocent person to prison, because it was the best and safest thing they could do for them. It's a scenario that haunts every public defender, every private defense attorney who has ever had a client they truly believed in. And it happens far more often than any of us want to admit. But what about the ones who refuse? The clients who, despite the crushing odds, despite the threat of a trial penalty, look their lawyer in the eye and say, "I didn't do this. I will not say I did. We're going to trial." When that happens, the entire universe of a defense lawyer shrinks to a single point. The focus becomes absolute. The game changes from one of mitigation and negotiation to one of all-out war. Because a trial is not a polite debate. It is not a scientific search for the truth. A criminal trial is a battle of stories, fought with arcane rules, psychological manipulation, and sheer force of will, where one person's freedom is the prize. The first thing you have to understand is that almost nothing you see on TV is real. There are no surprise witnesses bursting through the courtroom doors. There are no dramatic confessions from the stand. A real trial is a meticulously planned, highly choreographed performance. Every single word, every question, every objection has been thought through weeks, if not months, in advance. The battle begins before a single piece of evidence is ever presented. It begins with jury selection, or as the lawyers call it, voir dire. The myth is that you're looking for a fair and impartial jury. That is a lie. The prosecutor is not looking for an impartial jury, and neither is the defense lawyer. You are both looking for a jury that is secretly, perhaps even subconsciously, biased in your favor. You are picking a team for a game that is already rigged against you. The lawyer will get a list of potential jurors, their names, their occupations, maybe their neighborhood. And from that tiny bit of information, the guesswork begins. Is that an accountant? Might be very rigid, by the book, bad for a case that relies on a messy human explanation. Is that a school teacher? Might be more sympathetic, more understanding of youthful mistakes. It's a game of crude stereotypes and gut feelings, and it feels deeply unfair because it is. Then you get to ask them questions, and you're not really listening to their answers. You're watching how they answer. Who do they make eye contact with, you or the prosecutor? Do they cross their arms when you mention the police? Do they lean forward when the prosecutor talks about law and order? You're probing for hidden biases, for life experiences that will make them receptive to your story. You might ask a question that seems completely random, like, "What's your favorite TV show?" But you're not just making small talk. A person who loves CSI might believe forensic science is infallible, which could be a disaster. A person who loves The Wire might have a more cynical view of the justice system, which could be exactly what you need. You are, in essence, a casting director, and you are trying to find 12 people who are willing to believe in the movie you're about to show them. You're not looking for 12 people who will find your client innocent. You just need one. One person strong enough to hold on to a shred of doubt when everyone else wants to go home. Once the jury is set, the show begins. The opening statement is the movie trailer. It's the defense lawyer's one chance to speak directly to the jury and tell them, without interruption, what they are going to see. It's a promise. Over the next 3 days, the lawyer might say, the prosecution is going to tell you a story. They're going to show you grainy video and confusing documents. But what they're not going to show you is proof. They're not going to show you a single witness who can tell you under oath that my client did what they say he did. And by the time we are done, you will see that this case is not a straight line, but a house of cards built on assumption and guesswork. And it is about to come tumbling down. Then comes the heart of the trial, the examination of witnesses. The prosecution goes first, presenting their case. For every witness they call, the defense lawyer has one job and one job only during cross-examination: to create doubt. The single biggest misconception about cross-examination is that you're trying to get the witness to confess to lying. That almost never happens. What you're actually doing is controlling them. A good cross-examination is a series of leading questions that can only be answered yes or no. The lawyer is testifying, and the witness is just there to agree. Imagine a police officer on the stand. The lawyer won't ask, "Why did you arrest my client?" That gives the officer the power to tell their whole story again. Instead, the lawyer will break it down into 100 tiny pieces. "Officer, you arrived on the scene at 10:32 p.m., correct?" "Yes." "And it was dark?" "Yes." "The streetlights on that block are known to be faulty. Isn't that right?" "They can be." "So visibility was poor?" "It was okay." "It wasn't broad daylight, was it, officer?" "No." "You spoke to one witness, is that correct?" "Yes." "Did you get their contact information?" "No, the situation was chaotic." "So you have no way of recontacting the only supposed eyewitness?" "That's correct." "Did you test the substance you found for fingerprints?" "The lab did." "And my client's fingerprints were not on it, were they?" "No." "Did you find any of my client's DNA on the weapon?" "No." You see what's happening? The lawyer never called the officer a liar. They never even accused him of doing a bad job. They just pointed out all the things he didn't do. All the holes. All the gaps. They are not trying to prove innocence. They are trying to dismantle the prosecution's proof, brick by brick, until there's nothing left but rubble. They are injecting doubt into the bloodstream of the case. This goes on for days, sometimes weeks. It's an exhausting, relentless grind. The lawyer lives and breathes the case. They're running on 4 hours of sleep and 10 cups of coffee. Their entire life is a stack of papers and a list of questions. All the while, they have to be a rock for their client, who is sitting next to them, terrified, their life hanging by a thread, watching this slow, agonizing process unfold. Finally, after all the evidence has been presented, comes the closing argument. This is where the lawyer steps out from behind the rules and the procedure and speaks from the heart. The opening statement was a promise. The closing argument is the proof that the promise was kept. The lawyer weaves every little piece of doubt, every contradiction, every unanswered question into one final powerful story. They'll walk the jury back through the testimony, reminding them of the officer who couldn't see clearly, the witness who was never found, the forensics that proved nothing. They will look at each juror one by one and remind them of their sacred duty. They will talk about the awesome power of the state and how the only thing that stands between that power and the citizen is them. They will hold up the jury instructions and point to the two most important words in the entire legal system: reasonable doubt. They will explain that it's not just a phrase. It's a shield, a fortress. And if they have even one single nagging reasonable doubt about what happened that night, they have not just a right but a duty to find the defendant not guilty. And then it's over. The lawyer sits down. There's nothing left to do. The months of investigation, the sleepless nights, the strategic battles, it all comes to an end. The fate of another human being, their future, their family, their entire life, is placed into the hands of 12 strangers who walk out of the room. And the defense lawyer is left alone at the table, next to their client, in the deafening silence of the courtroom, to wait. It is the most profound and terrifying powerlessness a person can ever feel. Everything you could do has been done. The story has been told. And now all you can do is wait to find out how it ends. And that ending can take minutes or it can take days. The jury deliberation is a black box. You have no idea what's happening in that room. Are they arguing? Are they looking at evidence? Have they already made up their minds and are just eating the free lunch? You, the lawyer, and your client are trapped in a state of suspended animation. You try to make small talk. You talk about the weather, about sports, about anything other than the one thing you're both thinking about. You try to project an aura of calm, of confidence, but inside, your stomach is a knot of acid and adrenaline. You're replaying every moment of the trial in your head. Did I phrase that question correctly? Should I have called that other witness? Did that one juror who kept looking at his watch even care? This is the lawyer's own private hell. You feel the crushing weight of responsibility, knowing that the decisions you made over the last few days, weeks, or even years are now being judged, and the consequence of that judgment will fall entirely on the person sitting next to you. You try to prepare your client for both possibilities. It's one of the hardest conversations you'll ever have. If it's a guilty verdict, you say, keeping your voice steady, "This is what happens next. They will likely take you into custody immediately. Do not resist. I will be right here. We will talk about an appeal. This is not the end of the road." You're trying to build a tiny lifeboat in the middle of a potential tidal wave. And then you talk about the other possibility. If it's a not guilty, you are free to go. You can walk out that door and never look back. You see the flicker of hope in their eyes, and it terrifies you because hope is fragile, and it can be shattered into a million pieces. Then it happens. A sound that cuts through the thick, stagnant air of the courtroom. A knock. It's not a loud knock. It's just a simple rap of a bailiff's knuckles on the jury room door. But in that silent courtroom, it sounds like a cannon blast. Every head snaps towards the door. Your heart feels like it's going to pound its way out of your chest. Your client might grab your arm, their knuckles white. This is it. The wait is over. The black box is about to be opened. The jury files back in. This is a moment every defense lawyer lives and dies by. You're not just looking at 12 people, you're trying to read 12 souls. You're looking for any sign, any tell. The old courtroom wisdom says if the jurors look at the defendant, it's an acquittal. If they avoid eye contact, if they stare at the floor, at the judge, at the wall, it's a conviction. You watch them take their seats. Their faces are stone. They are unreadable. They have been instructed to be this way, but you can't help but search for a crack in the facade. You see one juror glance at your client just for a second and your pulse quickens. Is that a good sign? Or was it just a stray glance? You see another juror staring intently at the defense table, their jaw set. Your stomach plummets. You're grasping at straws, trying to divine the future from the subtlest of human movements. The foreperson hands a slip of paper to the bailiff, who hands it to the judge. The judge reads it, and their face betrays nothing. They hand it to the clerk to be read aloud. The rustle of that single piece of paper is the loudest sound in the universe. The clerk clears their throat. The room is so quiet you can hear the hum of the fluorescent lights. Your client is barely breathing next to you. You put a steadying hand on their shoulder. On the charge of, the clerk begins, their voice echoing in the chamber. We the jury find the defendant. And in that space, in that fraction of a second between the word defendant and the next word, 1,000 lifetimes play out. The entire case, all the work, all the fear, all the hope, it all comes down to this single solitary word. Not guilty. The word hangs in the air for a moment before it registers. Then the sound rushes back in. It's a gasp, a sob, a shout. Your client might collapse into your arms, weeping with a relief so profound it's a physical force. The family behind you erupts. The tension that has held the room in a vice for days, for weeks, finally shatters. You feel it too. The weight of another human being's life, a weight you've been carrying on your shoulders, suddenly evaporates. It's a feeling of lightness, of pure, unadulterated victory. You did it. You saved them. You gave them their life back. You shake their hand, you hug their crying mother. You watch them walk out of that courtroom a free person, blinking in the sunlight as if seeing it for the first time. There is no greater high in the legal profession. It's the reason you do the job. It's the moment that makes all the sleepless nights, all the stress, all the sacrifice worth it. But there is another ending to this story. Let's rewind that moment. The clerk clears their throat. On the charge of, we the jury find the defendant guilty. The word lands like a physical blow. It sucks all the air out of the room. There is no explosion of sound. There is only a crushing, deafening silence, followed by a single gut-wrenching sob from the gallery. Your client might not even react at first. They might just sit there staring into space, as the meaning of that word crashes down upon them. Their life as they knew it has just ended, and you are sitting right next to them when it happens. In that instant, your job changes completely. There is no time for you to process the loss. There is no time for your own disappointment or frustration. You are no longer their advocate in the same way. Now you are their shield. You lean over, you speak to them in a low, calm voice, even if your own heart is breaking. Listen to me. It's okay. We are going to appeal. This is not over. You are their only anchor in a world that has just been torn from its moorings. The judge will set a date for sentencing. The bailiffs will approach, and you will see the handcuffs. This is one of the most brutal moments in a courtroom. The clink of steel, the finality of it. Your client, who just minutes ago was a free person sitting next to you in a suit, is now a prisoner being led away. You stand up, you watch them go, you make sure they know you are still there, that you are not abandoning them. You tell them you will come see them at the jail as soon as possible. Then they're gone. The jury is dismissed. The prosecutor might give you a nod, sometimes sympathetic, sometimes not. The family is in pieces and you have to go talk to them. You have to explain what just happened, what comes next, and you have to do it with a strength you don't feel. You have to give them hope when you feel like you have none left to give. When the courtroom is finally empty, and it's just you and your briefcase full of broken arguments and lost causes, the weight comes crashing down. A loss is not just a mark in a professional ledger. You carry it with you. You carry the look in your client's eyes when they were led away. You carry the sound of their mothers crying. You go home that night and you replay the trial again and again and again. What could I have done differently? Where did I go wrong? It's a profound and lonely burden. Because whether you win or you lose, whether your client walks out into the sun or is led down a sterile hallway in handcuffs, your job isn't over. For the one who was acquitted, you help them get their property back, get their record expunged. You help them piece their life back together. And for the one who was convicted, your fight has just entered a new, even more difficult chapter. The battle for their future, for their humanity, now moves to the sentencing phase, where the story of who they are matters more than ever.